everybody, and welcome back to Men's Day Out, India's only portal that covers gender stories but from the other side. Joining with me today is a Supreme Court lawyer and standing counsel for Haryana government, Prateek. Thank you very much, Prateek, for joining us today.
My pleasure.
Prateek, why we are here is because this week we've seen two back-to-back orders from the Supreme Court of India where they have invoked Article 142 of the Constitution and granted divorce to a man who has been fighting an endless divorce litigation for nearly 2 decades. So Monday we saw the first order which came in where the marriage had taken place in 2002. The bride per se fled from the reception hall and there was not a single day cohabitation between the couple, yet the litigation lasted for 20 long years. Tuesday, we saw a similar case again where the parties had separated 16 years ago and the wife kept contesting. So Supreme Court stepped in and said that, this is a dead marriage. The emotional bond is completely broken down. And therefore, once again, they utilized their powers and granted divorce to the man. What was your reaction when you read these orders and you reacted to it very strongly on Twitter as well? So what was your reaction?
Yeah. So first of all, thank you for calling me over for such an important, topic of discussion. And before, coming specific on this answer, see, let me give you a brief background that what is the concept of marriage in a Hindu society, or, how, this organization, or I must say a social organization, in which the marriage forms a very basis of this particular whole community in which we live in. So see, Hindu law regards marriage as a, sacrament, indissoluble and eternal affair. I mean, the way the law has evolved and, as it is a matter of fact that the law has evolved from the customs. So, the institution of marriage also is, I would say, the law on marriage is just a common sense, and thereafter, the various intricacies which has come into this law, this has been derived out of, common sense. And I must say that there is a declaration of Manu that says that neither by sale nor by desertion is wife released from husband was applied only for women and not for man. So these all things have come from customs. Now, coming back specifically on your query. So see, we have to understand one very basic concept that out of, lakhs and crores of litigations, very few cases reaches at the door of Supreme Court, right? And there are a lot of litigants at the district court level who face the challenges of overpendencies in the courts, and where, we have a basic lack of infrastructure wherein mediations or, conciliations and these type of, alternate dispute resolution things are not being practiced and are not being also very well adopted by, the judicial officers, also by the local advocates, because there is a, dearth of knowledge and also resistance to change that the old age systems, the old age litigation practices, which has been carried out in our district courts, trial courts, that is being carried out, and that is the basic loss is of the litigants. See, a marriage which, examples like which you have given, that the lady ran away from, venue of the marriage, and there was not even a cohabitation and not even a single day when a person has, when a couple has lived together. It is a clear and classical example of irretrievable breakdown of marriage, because there is no chance that, after such long period of time, there may be even a slightest possibility that the couple may stay together. See, irretrievable breakdown of marriage has been, very well considered by the Law Commission, and in their last report, they have recommended that out of, all the grounds which are mentioned in Hindu Marriage Act, which are given for, for the purposes of taking the decree of divorce, such as mental cruelty, adultery is there, and some other grounds are there. So it should also be a part of this act, an amendment should come in. Unfortunately, it is yet to become a law, and legislative approval is required into that. But I think if this comes in, then there will be a lot of expediency in terms of getting divorce decrees, where it is absolutely crystal clear that both the persons in a relationship, they don't want to stay together, and there are facts and circumstances wherein a judge can clearly made out that there is no possibility that any kind of restitution can take place.
Right. As you rightly said, the Law Reform Commission has also been recommending this. And in 2010, they were very close to actually passing this as a law. However, once again, the entire decade has, gone by, and yet, this reform was never brought into. Now, one of the prime reasons at that time was, there was a lot of debate around what is the fair amount of compensation that could be given to the women in such cases. Again, where we look at the laws from the West, the terms that are used over there are spouse. So it is not specifically that only the wife could be entitled to compensation. But when, again, we look at India as a country, there was a dilemma that if people start using irretrievable marriage breakdown as a law, what would be a fair amount of compensation? So some said it could be 50% of the man's assets. There were suggestions of 50% inherited property also of the man. But nobody ever debated that, you couldn't perhaps look at a marriage which lasted only for a year, comparing it to a marriage which would have lasted for maybe more than a decade. So do you think if we are, going to structure this kind of law, and when we look at the compensation part of it, 2-3 things will be very, very critical. One would be the duration in marriage. One would be whether the couple has any kids. Other would be, the lifespan. So let's say if the marriage lasted even for 5 years, 7 years, but the woman can come back to her professional life. Would we even consider these things? Because if we don't, then even if the law comes in, the parties would again be in court for another 20 years fighting over the compensation. What is your take on this?
Right. See, first of all, let me make it very clear that many people, and I was also one among them when I, started my law degree, there are preconceived notions that compensations and maintenance are part of onus on the man, right? So the Act of Maintenance Act does not state this so. This can be reversal as well. A woman may be, earning better than a man. She may be better qualified. She may be at a better pedestal. Then she has a, legal liability to maintain that man. So, but of course, as I said in my, earlier submissions, that, all the courts, all the lawyers, they have this kind of preconceived notion that a man has to maintain a wife, right? Or a alum needs to be, given by a man to a woman. So that point, first of all, needs to be cleared. Then other thing I would say, see, the compensation part has to be, carved out in a manner that when you weigh a relationship, when you weigh a separation, and when you weigh the remaining part of the life, then you must, quantify that how the person at whose instance the divorce is taking place, or who is more eager, and the person who's left out, then how his basic standard of living, the existing standard of living, rather than not the basic standard of living, the existing, the way he or she was staying or maintaining himself or herself before getting into the institution of marriage. So that has to be carried out. So that has to be continued. So it should be taken into consideration that any kind of alimony or any kind of compensation by the way of maintenance, or through other ways, the person who is getting left out in the decree, or who has less resistance towards the divorce decree, that person should be adequately compensated, so that the same standard of living, the social security, and the psychological needs, the physiological needs, and maybe some necessary needs should be taken care of well by that court order. So that is part of this. Other thing which I want to specifically point out through your this men's day out platform, that I have seen in courts that uh, these laws are basically pro woman laws, and I have seen that just a simple case of divorce, if there are no grounds, people make it a ground for mental cruelty, which looks very obvious. And if the boy does not come to terms, then litigation, criminal litigation of 498A, 406, and now in some cases we see that many times. I'm just saying it off record, that many times people say that we want a boy should be arrested. Then people want that give a allegation of section 377 IPC. These are, I'm telling you, these are very ground realities which all must be aware of, that these things are happening. So I must appreciate that Supreme Court time and again has cut down on the powers of coercive actions by the police, wherein there was a time when we used to see that girls alleged in a FIR about the boy, the in-laws, or even the sisters, or even the brother-in-laws. There are FIRs, I can tell you, when the brother and sister-in-law was not even in the marriage, they were abroad, and they have not even seen the girl. They have not even met, but they were part of the FIR, and they had to face the coercive actions from the police authorities just because the girl has alleged. So that has been very well. I must appreciate that Supreme Court has clipped the wings of the investigating authority in these type of cases. Now the time has come that a mechanism should be derived out, wherein lot of women allege that there is an allegation of section 377 IPC. There must be some kind of mechanism, maybe through a medical way, or maybe some kind of evidence, because just because 498A, 406 allegations do not make it strong enough for a investigating authority to harass, or to maybe arrest a person. It should not be done in a mechanical manner that section 377 is added. That is my submission.
Right. You very rightly put in, Prateek. And also, what would be the mindset of these women, who are not living with the person for so many decades, so many years, yet they want to contest. Now, the way I look at it is, because our laws have been designed in such a way that whether you're married for a day or for 10 years or 20 years, you will be entitled to maintenance for your life. Whether it is in Section 24 of the Hindu Marriage Act, or it is Section 125 CRPC, or the Hindu Marriage and Adoption Act. So, there are endless avenues through which women can keep getting maintenance for life, and yet, not legally free the man. Do you think if we also look at clipping these kind of laws, probably, these endless litigations would also come to an end sooner or later? Otherwise, there is really no, how would I put it? There is really no incentive for a woman to let go the man. How do you look at it?
See, I look at I have a broader view, because we have to understand that India forms a part of this. When these litigations begin, we have to understand that these kind of litigations actually happens in metro cities. What you are seeing right now, what I am seeing practicing here in New Delhi, but these kind of litigations also happen in villages, in tier 2 cities, tier 3 cities, where women are really harassed by the in-laws, and they still the taboo of dowry, still the taboo of domestic violence takes place. So you can say it's a double-edged sword, where legislation has to very carefully examine that, in case if they stop these kind of provisions in law which you are mentioning, it may benefit to the people who are in metro cities, who are well advised by senior lawyers, who knows how how to get the thing settled in terms, I'm telling in monetary terms, vis-a-vis a lady who is sitting in a village in a tier 3 city, who do not have any kind of access of legal advice, or she's been really harassed, and she's been beaten by her in-laws, she's been taken. She's been the only purpose of marriage was for reproducing children, for making the woman as a slave, and doing all kind of illegal acts on her. So a good balance has to be carved out, which I think Law Commission in its last report has very well maintained. Now, see, there are two very extreme aspects in these kind of laws, because in metro cities, I see personally that there are countless and endless litigation which a woman carries. I can give you so many instances, like when a woman when a woman resisting a divorce, she contests the divorce petition. She files a FIR for 498A, 406, for even for 377. She files for maintenance in these aspects, and there are other forums. I have seen many senior government officers who were facing these kind of arm twisting from their wives, and they have reached up to the level of to the government authorities, to the Central Bureau of Investigation, to the EDs, to the income tax authorities, that such and such person should be investigated, their accounts should be checked, and whether any corruption is done or not. So are you getting my point, that a divorce, a simple divorce petition, where does it lead to? So it goes on to many places. So a clear balance has to be maintained, and I think the kind of judgments is coming. I can quote a very recent one, that is Shiv Sankaran versus Santi Minal. So the Supreme Court on this last Monday held that continued allegations and litigations against spouse amounts to cruelty under Section 13(1)(1)(a), that is the cruelty part of the Hindu Marriage Act, and it would be a ground for divorce. So Supreme Court understands this, it appreciates this, that the endless litigation by the woman must be taken as, if proved that it do not hold any ground for as a evidentiary value, it must be taken as an ground for cruelty by the family courts while deciding the divorce.
Right. Now, Prateek, I would like to put in a question from the men's rights activists, and there is this accusation which often comes from them, is the system themselves is a beneficiary to this, the whole gender bias laws, which, kind of promote and encourage these endless litigations. And that is why perhaps nobody, whether the government or anybody, is really interested in bringing any amendments to this, matrimonial laws in India. How do you want to counter these allegations?
See, just as I submitted, it is not about the system taking advantage. It is about the great diversity of our country. I'll put it straight across like this, that if you consider the litigants in Mumbai, New Delhi, Kolkata or Bangalore, they are class apart. They in terms of they are better equipped with all kind of legal knowledge, all kind of legal jargons, legal equipments, in knowing that what they can do and what they cannot do. But we have to take care of a person in a small town of Bengal or maybe Odisha or Tamil Nadu, and if that lady gets harassed, then these kind of laws come to her rescue. That is what because I'm also the counsel for National Commission for Women, and I see many genuine cases wherein women are being harassed. She's been subjected to cruelty. She's been subjected to unnatural, sexual activities. That is 377, and these are the real matters. But what I would like to suggest in these things is that a case like this should be reported immediately. It should come in the legislative act, like an allegation of 377. A woman alleging that such and such act happened 5 years ago, or maybe 10 years ago, then there should be judgments which should create a doubt on the prosecution story. I remember there is a judgment of Khazan Singh versus State of Madhya Pradesh, wherein Supreme Court clearly held that even a delay of 24 hours in lodging of an FIR will weaken the prosecution story. And here, in practicing in New Delhi, I see that the allegations date back to 2010, 2005. We are talking about 10, 15 years when the girl got married, and also the 498 allegations that these continued things are happening. So as a lawyer, when we are on the men's side, we always ask that any kind of PCR calls were made, any kind of medicals which has happened. This creates the evidentiary value. If nothing is there, then of course the prosecution story falls down, because they are just clear allegations and there are no evidence to that effect. But the problem is that on the basis of allegations, FIRs are registered, trials take place, and these trials are concluded in 5, 6, 7 years. Till that time, the boy gets harassed. This is the bottom line, which I want to say, that we have to save the time of this continued litigation for 5, 6 years. He may be acquitted, or a family may get acquittal after 5 years. But what about those 5 years wherein they face the prosecution on the baseless allegation? So a mechanism should be derived out, whereas there should be a strong law that on the basis, if there are any false allegations, and if proved that the allegations were baseless, there were no evidence, and it is proved that they were false, then there should a strict action should be taken against the complainant. And not only what is there, a very weak perjury law which we have. The boy side is never interested, because they know that nothing real going to come out of it. So on the other side, a girl or a complainant should always be aware that if I put a false allegation just for the purpose of creating hardship for the boy family, then she should be ready. If it is proved false, then she may also face the litigation.
You're absolutely right, Prateek. And I was going to tell you this, that, we absolutely understand that there are genuine victims, of domestic violence, and definitely they should, deserve justice. But when no court wants to really punish the false accusers, somewhere we are, being unjust to these genuine victims as well, because the courts are flooded with false cases, and there is really no deterrent for a woman today to go and file a false case, whether it is in matrimonial or even several rape cases where we see that it was perhaps only filed to settle a score with the man. So unless and until there is a proper deterrent, some punishment, and as you rightly said, perjury and all, it doesn't really matter. Nobody even bothers. I mean, I've seen a case where the man was awarded some 5,000, 6,000 rupees as compensation after 7, 8 years of a false 498A. So definitely, maybe that is also one of the things the court should consider if they're trying to fix in the system as a whole. And lastly, before we end, if you have to give 3 good suggestions, to bring in irretrievable marriage breakdown as a law to the government of India, what would those 3 critical suggestions be?
All right. So you basically want that what suggestions could be carved out for putting this irretrievable breakdown of marriage into an act.
So that there is fair justice to both the man as well as the woman, and no one side can take advantage and escape out of the marriage.
See, there can be several suggestions, but what I've learned from my practice on this side is that we have to introduce a very strong alternate dispute redressal system, not just a mere mediation in which even mediators are not empowered much enough to settle the dispute. They just, what I have seen in mediation is that they just record the statement of both the parties, and if they themselves agree, they record it and send it to the court, and if they don't agree, they do the same and send it to the court. But what should be done, that these mediators should be trained properly so that they can do some kind of conciliation and make both the parties aware that if the litigation will continue, then what is their loss, and they should settle it then and there, so a case disposal can happen. They should not be mere the recording agents. They should be conciliation agents who can really advise them that what are the pros and cons of this continued litigation. Other thing, the irretrievable breakdown of marriage must be included in an act. The reason being that if we see the litigation part of the divorce cases of 498A, 406, many times I see the boy side. And it is I must say it is a regular affair in High Court of Delhi also, where I also practice, that 498 406 हो गया, उसके बाद सेटलमेंट हो गया, आपका सेटलमेंट डीड बन गया, उसके अंदर आपका क्वेश्चन पिटीशन लग गया, and High Court में जाके, and we give a submission to Milords that that one party is handing over the demand draft to the other party. So it should not become a settlement ground. The FIR should not become a settlement ground. I must appreciate Honorable High Court of Delhi and Honorable Supreme Court that they have put a bar sanction on the settlements in offences like rape cases. Many times I have seen, maybe 3-4 years back, I can recollect that there were settlements which has happened in rape cases, but now there is a clear direction, there are clear judicial precedent that in heinous cases like rape, which includes rape, there cannot be any kind of settlement which leads to questioning. So it is not allowed. So it should also come in terms of 498 406, that if a settlement is happening, a judge should dig deeper that why this FIR for this purpose is totally instituted. And one other aspect has to be taken care of, that the prosecution agencies, our police, our investigating officers, they are not agents of getting it settled, right? You lodge an FIR, you get it settled, you get a question from the High Court, but what about the total criminal justice mechanism, that machinery worked for you for 3, 4, 5 years, and then you get into a settlement and get the FIR quashed? So the state resources are getting wasted. So my suggestion is that state should also consider these points when the police machinery is set into motion after registration of FIR. So there should be some kind of penalty, I may say, or there may be some kind of checks and balances where the efforts of our investigating officers do not go in vain. That is one point. Other thing, if we include irretrievable breakdown of marriage, that particular aspect should be left to be decided by the fine acumen of our judges. After reading the case, the facts and circumstances, if they feel, because ultimately what Supreme Court is deciding in 142, that Honorable My Lords has felt that there is an irretrievable breakdown. So they are doing it in their inherent powers, which our trial courts do not have. That they can only have once and it is incorporated in the act. But the act should also contain that it is it must be the discretion of a judge that after reading the facts and circumstances of the case, they may carve out that yes, this is a perfect case of irretrievable breakdown and marriage may not sustain and a continued litigation will not give any purpose. So they may declare a decree of divorce. So that is my submission.
Right. So on that note, the way you started, Prateek, when you said that, we look at Hindu marriage as sacrosanct, which cannot be broken. And while the Supreme Court of India has decriminalized adultery in 2018, we truly hope that they, look forward and kind of bring in, a ground for divorce, which is, which would kind of end these dead marriages. And also look at, deflooding the courts, which are right now doing injustice to a lot of genuine victims. I thank you very much for joining us on Men's Day Out, and we look forward to chat with you soon again. Thank you so much.
Thank you so much. And just one disclaimer that these all opinions are personal feedback submissions / opinions, and nothing should be associated with, the government organizations I am associated.
Absolutely. We take you on for that. And thank you once again.
All right. Pleasure.